All right. Welcome to this panel on worker data rights under GDPR and beyond, legal mobilization and enforcement across the EU. I'm Justin Oogheerde. I'm Senior Policy Officer at FES. That's the Friedrich-Ebert-Stiftung's Competence Center on the Future of Work. We are a social democratic think tank from Germany. And as you may have heard, the Social Democrats care quite a bit about work, about workers, about unions. We're close to the unions. And when you talk about work and you talk about digitalization, there's a whole bunch of risks and concerns that we have. So I'm really thrilled that we have this panel here at CPDP, where we look at the datafication of the workplace. And as the title already hints at, we're going to talk effectively about data protection in the workplace, and specifically how we can make worker data rights more effective. And yeah, why do we host this panel? Well, in our work the past 3 years, we've seen a lot of harmful data-driven management practices, online surveillance, algorithmic management practices that are clearly beyond what's allowed under the law. And what's a bit frustrating, it is often difficult to collect evidence about this, right? Because workers don't necessarily want to go out and spill the beans. They don't really want to litigate often because the risks are enormous. And so it's very difficult to gather evidence that's beyond anecdotal, unless it's the platform work economy, of course, where we have seen lots of court cases as well. That said, there are, of course, hints that show that there's a massive problem, in my opinion. What I found particularly interesting was the OECD study from last year, February 2025, where they did a big survey across managers in also 3 European countries, including Spain and Germany, for instance. And they asked them basically, do you use algorithmic management tools? And on average, 97% across the EU said yes, of middle management. But what I found most interesting was that 69% said that nothing to see here, nothing to worry about, because our algorithmic management tools don't process any personal data of any individual, nor do they do anything, track anything that's related to how workers do their work, which I found very comical, because like, why then do you use that system if it has nothing to do with workers or how they go about their business? And also the study itself said that this is clearly very odd and basically incorrect, right? Because obviously the vast majority of such systems do use workers' personal data. And for me that points to a problem, right? Because if managers don't even admit that they process personal data of workers, then it seems like a long shot that they would actually comply with the law that governs personal data processing in the workplace, the General Data Protection Regulation, the GDPR. So in other words, our suspicion is that there's a very high degree of non-compliance, and that provoked us, and with us I mean FES and the Arbeiterkammer Vorarlberg. Arbeiterkammer is the Chamber of Labor, which is a specific Austrian institute. So it prompted us to look into data protection rights in the workplace. So what is happening, what's happening in enforcement across 10 European countries, what are the bottlenecks, why is not more happening, to sort of like confirm our suspicion or perhaps disprove it. And so what we're going to do in this panel is basically build a bit on that report. So we first have Giovanni Gaudio from the University of Turin to present the report. He's the co-author of this report that came out in December last year. And it's great because he's a labor lawyer as well. So he also has this practical background, working at Freshfields in the past. Now he's a scholar, focusing specifically on labor law and digitalization, AI, so a very relevant background. And what Giovanni will do is present the report, short highlights of what we found. And then afterwards, we're going to get reactions from the other panelists. And again, I'm really excited for that, because we have first with us Marta Otto, who's a labor law scholar from the University of Warsaw. Expertise is comparative labor law, international, European, and specifically focusing on all the topics that we care about, so privacy, data protection, algorithmic management, digitalization, and so on and so forth. And she also worked in a distant past, at the Polish DPA. So a great perspective. We have also with us the current enforcement perspective with Oksana Karakush from the Hamburg Data Protection Authority and for Data Protection and Freedom of Information. I always forget that you should add that in Germany. And you've been working for the past 5-6 years specifically on employee data protection, both for the public and the private sector. And you had basically the Economics Affairs Division at the Hamburg DPA. So again, extremely relevant for this discussion. We're looking forward. And last but not least, we have with us Thomas Tzedik. He's the head of unit of supervision and enforcement at the European Data Protection Supervisor, the EDPS. And he really covers in his work investigations, systemic issues around enforcement, corrective measures, high-risk processing. Before he headed the technology, privacy, and IT policy unit at the EDPS. And what I didn't know, he, in a, again, also distant past, worked specifically on the GDPR in the Commission, also on the labor law provisions of the GDPR, so Article 88. So again, extremely relevant background for this discussion. There will be ample time for questions, so we hope to see some that the discussion sparks some reflections from your side. We're very open to that because this is also a collective learning exercise. So we really want to involve you in that. With that, I want to hand over to Giovanni to present the report.
The slides. Okay. So thank you very much, Justin. It's a pleasure to be here. So my role, as Justin said, is just to kick off the discussion regarding the reports that we published in December 2025. That is worker data rights under the GDPR and Beyond, enforcement and legal mobilization across the EU. As Justin said, in the last years, data protection in the workplace became even a bigger topic than it used to be due to the rise of algorithmic management. And as labor lawyers, when we refer to algorithmic management, we refer to those practices that have been used to monitor, control, and even discipline workers. At the beginning, this expression was coined to indicate a phenomenon that was very spread among digital labor platforms. So companies, ride-hailing companies such as Uber, food delivery companies such as Glovo and Deliveroo massively use these algorithmic management devices to manage the workforce. But now, platform work is just the tip of the iceberg of a phenomenon that is rooted even among conventional workplaces, in which employers use these kind of practices to make automated decision-making against the workforce, going from hiring to performance management to firing, okay? So the topic is even more pressing today. As Justin said also, there was already circumstantial evidence that the GDPR may have not been widely applied in the workplaces. So what we wanted to do is to look in enforcement practices, especially member states, to see whether this hypothesis was actually well-grounded. And what we did was to map enforcement in 10 European countries that are the countries that you see in the slides. So we collected the reports from national experts, and the results that this research gave to us was that actually the hypothesis was kind of well-grounded, because especially in certain states, we found a lot of under-enforcement of the GDPR. And what we also found, we found a lot of fragmentation on how data rights are implemented in certain member states and how data rights are enforced in certain member states compared to others. So now, my role will be to present the main findings of this empirical research among member states, and my presentation of the main findings will focus on 3 areas. The first one is the area regarding the regulation, so how data rights are actually provided within member states. So in other words, there is Article 88 in the GDPR that allow member states to provide more specific rules regarding data protection at work. Our job was to look how Article 88 was implemented in member states. The second area that we are going to look at is specifically enforcement. So we look at how data protection rights are enforced both before data protection authorities and before courts. Third, since we are employment lawyers and research was about the workplace, we have special actors in the workplace that are workers' representatives. So we wanted to check what was the role of worker representatives in this discussion, and especially we wanted to understand if workers' representatives had any roles in the enforcement of the data rights in the workplace. So our main findings are the following. We will start from how data rights are actually implemented in the member state. As I said before, we found a lot of fragmentation among member states on how data rights have been actually implemented. And we can see that this fragmentation goes along two axes, a vertical axis and an horizontal axis. We start with the vertical axis that refers to Article 88. As I said, Article 88 recognizes the specific nature of data protection in the workplace because it explicitly recognizes and gives member states the possibility to adopt context-specific data rights in the workplace that normally, especially certain member states, recognize these specificities, giving these rights not only to individuals, but also to collective actors such as worker representatives. The problem is that the picture in member states is very fragmented because there are a group of states in which the specificities of the workplace context has been given a lot of attention and the involvement of workers' representatives have been huge. For instance, in states such as Germany, Austria, Luxembourg, and Italy, workers' representatives have co-determination rights over the introduction of new technologies in the workplace. While in other states, we have less or nothing, no involvement of collective actors. Also, when we look at algorithmic management practices, we see a lot of fragmentation because when algorithmic management became a topic in the workplace, certain states specifically regulated algorithmic management in the workplace, tailoring specific rights, data protection rights to the phenomenon. The first one was Spain, that then was followed by other states such as Italy and Germany. But if we look in other states, among the 10 that we actually researched on, in other states, there is nothing about algorithmic management. So the picture is a picture of fragmentation, and there is no harmonization at EU level wide regarding data protection rights in the workplace. A potential solution would have been more guidance by European authorities on how to harmonize data protection rights in the workplace, but actually we also lack misharmonized, updated guidance by European authorities on how implement data rights in the workplace. And that was the vertical fragmentation, so the relationship between the GDPR and national laws. But now, after 2024, we also experience horizontal fragmentation at the EU level because the specificities of the workplace have been even recognized by the EU legislature when in 2024 adopted the Platform Work Directive that at Chapter 3 provides certain specific data rights tailored to the specificities of the workplace. If we look at the Platform Work Directive, we see that, for instance, information and access rights, the right holders are not only the individual workers, but also the worker representatives. Also, worker representatives must be involved in the data protection impact assessments, and workers' representatives must carry out the human oversight over automated decision-making in the workplace when you deal with digital labor platforms. Now, these rights are rights that are specifically tailored to the workplace. The problem is that the scope of the directive is not wide enough because it only applies to digital labor platforms, but as we said before, algorithmic management practices nowadays span across all sectors and all employers. So there is also fragmentation at the European level because we have specific rules for the workplace, but these rules only apply to platforms. Second topic, enforcement. So now what we have found is uneven enforcement of data protection rights in the workplace among different countries. But before going to our finding, we have to specify something. Because what we wanted to do, it was a really empirical research, finding hard evidence about the number of cases. But every national expert had a lot of difficulties in finding comparable numbers. Why? Because especially with certain DPA, we have find limited DPA transparency on number of complaints received and decided, and especially we missed specific figures against work related to workplace cases. And also when we looked at courts data, for higher courts, you can find actually the cases, but in many states it was difficult to find lower courts decisions because they are not always published. So we have some figures, we have some data, but honestly, the data we have found out, they are not always comparable. Having said that, what we have found? We have found that there is a general under-enforcement of the GDPR in the workplace, and in certain states is very scarce. For instance, if we look at the numbers in Ireland, Austria, and the Netherlands, there are very few cases regarding data protection rights in the workplace. In other cases, the trend is different. For instance, all the experts from Belgium, Germany, and Spain recognize that there has been an uptake in recent years in the number of cases decided, both by DPAs and courts, and there is only one outlier, I guess, especially if you look at the DPA, that is the Italian Data Protection Authority, that historically has decided a lot of cases and a lot of high-profile cases especially. When we look at topics, most cases are about classical monitoring, such as video surveillance, monitoring of emails, GPS tracking, and so on. But in some states, we have found the first cases regarding algorithmic management. So the Data Protection Authority in Italy decided 3 cases regarding algorithmic management in platform work. In the Netherlands, there were some court decisions against Uber, and also in France and Germany, the Data Protection Authority decided algorithmic management cases against Amazon. But these cases are just like high-profile cases, but algorithmic management is not really a widespread topic in enforcement nowadays. When we look at the mechanics of enforcement, we have found a clear distinction between the enforcement before data protection authorities and the enforcement before courts. Generally speaking, this distinction is clear. When you want to enforce directly GDPR rights, you go to data protection authorities. And many cases before data protection authorities are about the principle of processing and especially about information rights, especially about access rights, because workers exercise access rights a lot, so there are a lot of cases about data protection authority on how data controller responded to these requests. On the contrary, we have found very few cases regarding the most innovative provisions of the GDPR, such as data protection impact assessments and automated decision-making. Honestly, the only big cases regarding automated decision-making were the ones decided by the Italian Data Protection Authority against food delivery companies. In courts, the story is very different because normally workers go to courts not to enforce directly data protection rights, but they normally go to enforce labor rights, and then data protection rights have an ancillary role. Mostly, this ancillary role is played in 2 ways. The first way is that we have found a lot of cases in which workers try to claim that if the information that grounded a decision of the employer, for instance, a dismissal, was based on data that were collected unlawfully in violation of the GDPR, then this data cannot be used as evidence to ground the dismissal, and then the dismissal will be illegitimate. So this is the first good interplay between data protection rights and labor rights. The second one is centered on the right of access. Now, in the employment relationship, there is a lot of information asymmetries between employees and employers, because employers have much more information than employees. So for workers, once in a while, it's different to collect information to grant their claims. What we have seen is that increasingly, workers are using access rights under Article 15 of the GDPR as a discovery mechanism. They collect information before the claim, and then this information are used as evidence within the claim to ground the claim. For instance, you work overtime, You don't have evidence that you work overtime. You exercise the right of access. You have the evidence regarding the amount of time that you work, and then you file a labor claim to be paid the overtime you worked. So that's another positive interplay. What's the problem here? That the Digital Omnibus wants to put a stop on it, because the Digital Omnibus provides that the right of access can be exercised only for purely data protection purposes. So here the risk is that if this reform is going to be approved, then this positive trend that we've seen between data protection rights and labor rights may not be there anymore. Third point, collective enforcement. So I said before that we wanted to look at how worker representatives, what worker representatives did in enforcement. Our hypothesis was that for many reasons, worker representatives are in a better position to enforce data protection rights compared to individual workers. The problem is that we have not found cases with worker representatives bringing directly claims before data protection authorities and courts. Why this is happening? We think that this is happening because Article 80 of the GDPR, that could have helped in collective enforcement, actually has been applied in a way that is not delivering its promises. Why? Article 80, there are two paragraphs. Paragraph 1 provides that representative entities can bring a claim on behalf of the worker with the express mandate of the workers, while paragraph 2 provides that representative entities can do the same even without the mandate of the worker, okay? Now, the problem is that paragraph 2, in order to be implemented, it's an opening clause, so member states can decide if implement it or not. What we have found is that most states have decided not to implement paragraph 2 of Article 80. That would have been the most powerful tool to bring such claims. But we have also found that a lot of states did not clearly specify if worker representatives were among the representative entities allowed to bring claims under Article 80, and some states, such as Italy, also expressly provided that workers' representatives are not among the representative entities under Article 80. So the result is that very few cases brought by workers' representatives in the data protection field. But we have also found something interesting, because in those states in which data protection rights have been given not only to individuals, but directly to workers' representatives, then workers' representatives actually enforced these data protection collective rights and actually successfully enforced these data protection rights. That for us, it is a good message because it confirms the hypothesis that workers' representatives are better placed than individuals in enforcement. They are also keen on enforcing these kind of rights. The only problem is that in order to do that, the legal system should be conducive to this type of enforcement. Now, last slide, and I'm closing. Policy options. The first policy options deal with the fragmentation issue that we have seen in the regulation. So our first proposal would be to develop a EU-level harmonized workplace-specific guidance. We have seen that there is a lot of fragmentation among member states because Article 88 is, the idea is good because it says we need the workplace-specific data protection rights. The problem is that it does not deliver its promises. So we need guidance, maybe by the EDPB, to provide updated, harmonized guidance on how data rights have to be implemented in the workplace. Second policy recommendation, strengthen DPA reporting. We believe that we need evidence-based reforms to the GDPR, not like the ones that they are doing with the Digital Omnibus, actually. And when we try to collect data and evidence to make our policy proposal stronger, we had a lot of difficulties because actually these data are not harmonized and are not fully available. So before making any reform in this field, I think that we have to work on the data, see what's happening on the field, and then make decisions based on them. Third policy proposal, protect the right of access. Actually, the right of access is one of the few rights that actually had a good enforcement in European workplaces, and also the right of access showed a very positive interplays between data protection and labor rights. So the amendments that have been proposed in the Digital Omnibus go against this direction. There is evidence the right of access is working. We have to protect the right of access, not limiting its scope. Last, GDPR-focused policy proposal, maybe make little tweaks to Article 80, because Article 80 is a very powerful tool to make enforcement better, but actually the most powerful tool, which is paragraph 2, is an opening clause, is not mandatory for member state, and this is not giving representative entities the real opportunity to bring collective claims that may help in making the enforcement of the GDPR in the workplace better. But the main point, the broader policy point that we have is that since we have seen a lot of fragmentation regarding data rights in the workplace, both at vertical level, so in the interplay between the GDPR and the member states, but also at horizontal level, in the interplay between the GDPR and the Platform Work Directive, we think that it's time, after years of discussion about this, to recognize the specificity of the data protection in the workplace and to provide some general rules that recognize the specificities of data protection in the workplace, involving also collective actors in the field. So, as for me, I think it's everything. Thank you for your attention. Back to Justin.
All right, thanks so much, Giovanni, for the very comprehensive overview of what we did in the report. As you said, there's three main findings, right? Or three main focus areas. So it's fragmentation, it's under enforcement, and it's a lack of collective enforcement, basically. And I would like to move now to Okshan for the first perspective from the enforcement side. Because, of course, in the report, we talk about what we think is a pattern of under enforcement. We also talk about the potential of collective rights. So it would be really interesting to get your view on that. So what have you seen at the Hamburg Data Protection Authority when we look into employee data protection? What are the trends? What are the hurdles? And do you, for instance, do you also see or don't see what we think in a report is any sort of like use of Article 80, for instance, that workers, mandate unions to take action on their behalf, for instance? Not even speaking of Article 80/2, because that's not, I think there's no evidence for that right now. So please.
Yeah, thank you very much, Justin, for introducing me and us, and thank you, Giovanni, for the presentation. Let me ask you to go back on this slide, because I think it's much easier to understand what I will tell you. Not the policy options, but the other, I think that was the slide before that where you had the three, this one, the key findings. Okay, my name is Okshan Karakush, and I'm working for the Data Protection Authority, or the Data Protection and Freedom of Information Authority in Hamburg. For Thomas Fuchs, this is my commissioner, and I'm responsible since 2020 for employee data protection in the public section and also in the non-public section. And just to have an idea, we have about 80,000 employees in the public section and about just about 1 million employees in the non-public section. And my time is, I have about 50% of my time is, I'm doing this is my major employee data protection work, so it's about 20 hours a week, just to have an idea. The problem is, well, if you work for the public and non-public section, and if you look at the GDPR, for example, you have different rights as a data protection authority. So in the public section, we are talking about, we have to, the processor has to, the controller has to, consult us if they want to implement a new tool. We tell them how to do that, and if employees come to us, and if they have a problem with their data protection rights, there is actually not really much we can do. This is what we say as a fact. We don't have so many enforcement rights. We can say you're not allowed to do that, but that's about it. We can issue a warning, but there is not really going to happen anything except, okay, they change the data processing. It's different in the non-public section. In the non-public section, we're actually allowed to fine companies. This is it makes a really big difference. And if I have or can give you an example, in 2020 we had the big H&M case. I don't know if you remember that case, where the processor was surveilling their employees, and my authority fined H&M with 35 million euros. And that's I don't know how you said that in English, but it's a shocking situation for the companies, for the processors, and also for the controllers, because they are aware if they work against the GDPR, if they process against the GDPR and they have no legitimate ground for their data processing, they're able, we can find them. So they're aware of that, and that actually help us in the sense of data protection. The problem is that we don't have many cases like that. And we have a lot of complainants, but not on the same company. And you cannot, with every complainant you cannot find immediately the processor. This is one major problem we have. And
H&M, there were lots of complainants.
H&M was a specific situation. We had a lot of complainants, and we had the press that was talking about it. And so the commissioner had a lot of pressure also to investigate. That helps us a lot. I'm honest. If the pressure is coming from outside, that helps us a lot to focus on one company. This is one point, and the other point what you were asking about Article 80 GDPR. I'm not quite sure if Germany is the right the correct European country to talk about it, because we are a federal state and we have 16 federal states. So 16 different, we have the GDPR, and then we have 16 different data protection laws. This is one thing that makes it a little bit difficult, but with collective enforcement, we have two problems. We have the unions on the one side, and we have the work councils on the other side. And the specific situation in Germany with the work council, for example, is that we have a law since 2020 that says that the work council is part of the controller. So that makes it difficult for us, because if the work council comes and consults us, it's the same as the controller comes and consults us. So there is a dilemma. So I would say you really cannot do that. But in fact, I think for us, if we focus on Article 80, it would be much easier, because we would have to deal with experts rather than with single persons. That makes it easier for us. Just to compare it as an example, if I usually don't talk to the controller, I usually talk to the data protection officer, because the data protection officer is always the one who understands my talking. He speaks the same language as I do. The controller and or the processor, they don't understand anything. So the first thing when a complainant comes to me and I have to approach the controller, or sometimes I have to approach the processor, I always ask, who's the DPO? Let me talk to the DPO because he speaks my language. And if it comes to the enforcement side, of course, I have to talk to the controller and the processor. But I'm dealing actually with the DPO.
So if I summarize that, if I'm saying correctly, you're saying there's a lack of complaints and pressure, basically, sometimes to act in specific cases. And you're saying that on the other side, it's sometimes difficult to have a counterpart that you can talk to in the company. Like if it's a DPO that works, Article 18 would actually be very helpful if you have somebody who's can systematically take on these cases from like a worker perspective.
Exactly.
That's very interesting. With that, let's move on to Marta. Marta, you've been working a long time on, of course, labor law and the intersection of privacy, also with, of course, GDPR, as I mentioned before. So from your perspective, have you seen any changes in enforcement trends? And like, how do you see some of the points that we make in the report about like fragmentation? Do you think some kind of guidance could be useful in workplace context? How do you look at those challenges?
Yes, I'm going to start from explaining myself because I have a very particular research fixation, which is all about regulatory models. So if you look at what we are experiencing when it comes to enforcement in the employment context, well, my research strongly confirms the report's diagnosis. What is really said to some extent is that this diagnosis matches very much the concern that was raised already in the 90s by Spiro Smitis, by Mark Friedland, who were calling for employment-specific framework under the directive from 95. And here we are, like 10 years after the adoption of the GDPR, and basically one message stands out really clearly, the one about the persistent, throughout the last 30 years, regulatory and enforcement divergence, which, by the way, translates into lack of legal predictability, but what is even more troubling is lack of coherent, standardized model of protection of employees' privacy within the EU, right? And in that context, what we see as people who are, again, like looking at the regulatory model is that this context and these divergences, they produced a particularly troublesome situation, which I call a functional sovereignty dilemma. Because those are the employers, in fact, that de facto take the roles of the regulators in the employment context, and they do delineate the so-called, to use the language of the European Court of Human Rights, the reasonable expectations of privacy, the reasonable expectations of data protection, right? And this is crucial because it is very much embedded in the deeper structural deficiency of the GDPR itself, right? Which is all about the so-called collaborative governance model, right? But this collaborative governance model, it translates into a broad discretion at the employer side, and of course, discretion that is becoming more and more structurally asymmetric. So what I saw when I was also trying to consult every now and then both trade unions or like working of counsel to a few law firms, is that this whole ecosystem produced really an impressive architecture of documentation. So we saw lots of risk assessment, privacy policies, DPIAs. But, so of course, to some extent you can argue like it builds up the procedural transparency, right? But it does so at the cost of the normative depth, right? When it comes to balancing of the conflicting rights and interests, there's no normative depth, right? So we arrived at the situation, at the regime that very effectively manages the mechanics of data protection, but it's like not possible under this framework to address the underlying and deepening asymmetries of power, information, agency, and so on and so forth, right? Is there a way out? Yes, there is a way out, and we can discuss about different options, right? But you asked me about the guidance, right?
For instance? Yeah.
For instance, the guidance. Yes, we do need a guidance, an updated guidance on employment-specific modern realities of the workplace, which is more data-driven, more interconnected than ever, right? And I find it, and I'm going to look at Thomas, sorry, that the European Data Protection Board is really uniquely positioned to provide such guidance. Why? Because of the institutional composition of the EDPB, but also because of the well-established practice of public consultation. And this is what we are missing for years now. We are missing a kind of societal consensus, not like one-sided vision of what is right, what is wrong from the employer side. We are missing the societal consensus, more dialogue between different stakeholders, trade unions, NGOs, employer sides, and so on and so forth, policy makers, right? What is right, what is wrong, where to delineate the line in between different employers' interests and needs, organizational ones, right? And on the other side, the employees' rights, fundamental rights, right? Not only right to privacy, but all the sort of correlated rights, like right to work, right to just and fair working conditions, and so on and so forth, right? And now I say that I've come across, that's my recent discovery, I'm sorry, probably I've been ignorant for years. I've discovered this super fascinating coordinated enforcement framework, which, well, is happening for years. And we were discussing it a bit, that this is interesting too, because what we are missing right now specifically, and this is a strong message, I think it's the main takeaway from this report, is that we are missing an evidence-based policymaking, not policymaking based on our opinions, on what we think. No, we need evidence-based policymaking. We didn't find much, as you could hear, through our very modest research, right? So in this context, this coordinated enforcement framework sounds promising, right? As a way of cooperating and trying to coordinate a bit the situation in between different national DPAs and to see what's going on, right? And then once we know what's going on, like what type of complaints, how successful they are, how they're being brought in terms of numbers and substance, then we can think of like how to unlock the potential of Article 88, because we'll have evidence. It's going to be either the national level or EU level, or maybe both, right? But we'll have proof. So yes, we need guidance. But at the same time, and I'm sorry, I know that I'm researcher, so you're not expecting like definitive answers from my side, right? You're like, we are known for asking questions and checking hypotheses, right? Yes. But I'm gonna give you a more definite answer. I think that thinking that the guidance is enough, it's wrong, right? So there is a caution that we need to pronounce, that we must really avoid the illusion that the soft law will fix all the structural deficiencies of the regulatory framework. And we have to work on that.
Thanks so much, Marta. And of course, also something I totally forgot to mention, that you actually collected a lot of the evidence for Poland itself that fed into the report. So big thank you, and I'm remiss for mentioning that. I feel that there were some direct questions now to Thomas, so I would like to hand over to you. There's of course the question of guidance at the EDPB level. I know that's not directly something that you're responsible for, as I understood it, but it would still be great if you can comment on that. I also know that, of course, you have been working on a GDPR, so I would also be interested to know how you look at the policy options and the policy ways forward that could improve worker data rights, enforcement, implementation at the workplace. So yeah, I would like to hand it over to you.
Okay, thanks, Justin. I'll try my best. First, also, thanks to Giovanni for the report. I'll try to answer the questions, but I also want to come back on two of Giovanni's report's findings. First, to set the scene, as head of supervision and enforcement in the European Data Protection Supervisor, I supervise a perimeter of roughly 60,000 EU staff across 75 EU institutions, offices, bodies, and agencies in 27 member states under one single regulation, the EU DPR, not the GDPR, but the EU DPR, which I always call the prettier sister of the GDPR because we have more rules. I can explain. And that EU DPR is applied by one single supervisor, who, by the way, is sitting with us in the room today, the European Data Protection Supervisor, Mr. Wojciech. So, in effect, we do have a harmonized enforcement room, contrary to what you claim is missing at national level, but we do have it. Does this help? I can give you a figure. We have around 60% of the complaints which we are dealing with at the EDPS, they come from EU staff. And what do? They complain about their own institutions, mostly about not having been provided with their personal data which they had asked for. So I can also confirm that the right of access is used as a de facto discovery tool because it exists, it's there, and other rules and regulations at this level don't provide for it, so the obvious way is to go the data protection way. So for us in our daily work, the workplace is not a niche, it's the center of the caseload. So two reflections on this. On enforcement, I said already, we have one single regulation, one single regulator. We can actually issue administrative fines on the EU public administration. And we have one designated data protection officer in every EU entity. But we do still meet the same practical constraints which your report documents, which happens also in member states. It's for us, therefore, not a problem of fragmentation, it's a structural issue. And why is that? It's the practical constraints. We are asked to prioritize cases and complaints under finite capacity. Many complaints coming in, audit obligations, investigations, personal data breaches, and they all compete for the same small team. I have 30 colleagues in my unit. So plus 10% of all the complaints are clearly also abusive. One has to say that as well. And which is unfair to the other complainants because it binds resources, a lot of resources. And more, and we've discussed this with Okshan, and we can see this across the European Data Protection Board and all data protection authorities, more and more complaints are being written by AI. That immediately expands the width, the breadth, and the silliness sometimes of the arguments, but it's clearly more work. Maybe one constructive point, Giovanni, you were rightly claiming that there is a black box between complaints and complainants and what data protection supervisory authorities produce. I agree. We have decided in the EDPS that we are going to publish our complaints decisions because we have realized that publishing our complaints decision is in itself an enforcement component. It builds a body of precedent, it guides controllers before the next violation, and hopefully it'll help the next complainant to see, okay, there was already the decision from the EDPS, and I can quote that and use that in my dealings with the controller or in this context with my employer. We are still preparing that. It's not live yet, but hopefully very, very soon. Then on your second point on the fragmentation and how should that be addressed, again, from my perspective, a very easy answer, let's use the instruments we already have. Direct enforcement is key. Guidance as well, there is already guidance on employee context and workers' rights from the European Data Protection Board. It's been maybe it needs to be updated, but I tend to agree with Marta. The EDPB's coordinated enforcement framework is a great idea because it lets data protection authorities work together to run a joint annual enforcement action on one shared topic. So working on workers' data rights would be, for me, a natural choice, for example, for the future. And then that means supervisory authorities can focus on that topic, which most of them probably haven't prioritized ever. And I see from your findings that even though from me, from a personal enforcer's perspective, the coordinated enforcement framework runs a bit short because I'd like to see concrete enforcement on the ground, but at least the data would be then there. You would have from all participating supervisory authorities their input, their reports, including from the EDPS, on how workers' rights or the employment context rights would be dealt with. Last but not least, on the frameworks, again, I said there are ideas of standalone algorithmic management directives. We have the AI Act, we have the Platform Work Directive. My personal view is if there is a genuine need for harmonizing rights, let's do that, please, under the GDPR or, in my case, under the EU DPR. We don't need another separate instrument which creates more fragmentation because then that's good for the lawyers, including myself, but it's probably not easy then to apply. And we've seen that discussion already on the Omnibus. Last but not least, collective enforcement. There you clarify the situation, and I can confirm it's the same situation under the EU DPR. Staff representatives in our world, staff committees or trade unions have no data protection rights on their own. They can only work on an individual basis per mandate on behalf of some others. Again, personally, I think if there was collective enforcement representation, I would welcome this because then you have professionals who know what they're talking about and you could clarify one specific situation in one go for systematic questions, and that would help immediately everybody else who is in the same situation. But again, that's for future legislation. We don't have that yet. Again, from my perspective, final thought, the fragmentation is not because we lack rules, it's because the rules have been designed by different people in different rooms. So we need to work on making that coherent and effective. Thank you very much.
Thanks so much, Thomas. There was really a lot to unpack there. I really liked the plans you shared also for making the EDPS's decisional record of decisional practice more transparent, which I think would also reduce the workload in essence. And that's, I think, the kind of transparency that would be extremely helpful across Europe. Points also taken on the enforcement side, on the fact that for you, at the EDPS level, of course, it's not fragmentation, but it's the structural constraints that we all have to deal with, obviously. I do have a question there later on standardization, but I first want to go to questions from the audience, because I have the feeling there are some specific questions that we would like to give the floor to. So first, I would like to give the mic to the data protection head of the EDPS, Wojciech, please.
Thank you very much. Well, using this opportunity that Thomas is among the panelists, I would like to, for the first time in my history of being at the CPDP conference, speak not as the EDPS or the National Data Protection Commissioner as I was before, but as an academic. So please don't treat anything which I say now as the position of the EDPS, but rather my observations as academic and the question as well. Well, starting from the question probably, if you can go to the next slide that you have. Of course, I fully agree with the claim of lack of harmonization and fragmentation that was well visible when the GDPR was under preparation. Mm-hmm. In the draft, there was nothing about, there was this exception for the labor law in the draft. Then there was a long discussion in the parliament, which finished with nothing. Mm-hmm. And my question is, does it mean that politically there is no way to create the level playing field for the labor law and data protection on the European level. That's true that the country which was the most against, meaning UK, is not a member anymore. But I think the differences are too big to have the political agreement on that. Is it also something that you can talk about? The second thing is about the right to access. Well, I think that the person who proposed in the draft of the Omnibus to remove the right to access to the non-typical data protection issues should be prosecuted. That was so much against the rights of the workers that I cannot really believe that it happened. And the last thing is about the collective enforcement. Am I right that the problems are not actually with the data protection law, but rather with generally collective enforcement and harmonization of that? And this is also only the reflection of the more general problem.
Thanks so much for those questions and remarks as well on the omnibus. I think most people agree. I think everybody agrees, frankly. Let's take two more questions and then we do a round of answers. Is there anyone who would like to take the floor? Please, the lady in red, and then Eva, I saw your hand going up, and then the floor to the lady here in front. Thank you.
Hi, I'm not sure if this is too much of a specific question, but I was wondering when you mentioned the omnibus and right to access, even if these changes do not pass, I noticed also that the CJU also seems to take the approach of handling, or takes the approach that there needs to be something done for quote-unquote abusive requests with recent cases such as the Berlin-Rotler case. I was wondering, even if these omnibus changes do not pass, do you think the CJU ruling might make it more difficult for the enforcement of this access to these rights to access?
Yeah, you all confirmed something that is an observation coming from a trade union and labor representation background, that there is very little awareness and then also action from workers themselves about the data breaches, or if there is, it's kind of considered normal nowadays. So the bigger question that I have in my mind is, do we need a new discovery mechanism? So you were discussing right of access. I'm thinking about something much broader, which is why does the employer get all the data? Why does the supervisor, the worker representatives have no access to all this data when actually they have statutory rights, both labor rights, works council rights, etc., investigation rights for the supervisory authorities? That's one. The second one is, does it need a public prosecutor or somebody, we were talking about collective enforcement, but somebody that actually brings more claims on behalf of workers or takes up systematic issues? Because you've said most claims that are being brought are by individuals, if claims brought at all. Now, that does seem to be doing very little to stem the endemic wave of algorithmic management and digital sort of work monitoring tools that we've heard throughout this conference. So those are my two questions.
Thanks so much. I think it was the first question from Wojciech on the lack or potential of political agreement on employee data protection at an EU level. Does anyone feel called to go into that?
I can try. Yes, there is this persistent lack of political willingness to tackle a bit differently employment-specific contexts. We saw the same lack under the directive, right, when they've tried to have a bit of consultations with social partners, I think in 2001, and then a few years later, nothing appeared on the scene, right? But if I'm reading correctly still the GDPR, I think if you look at the very essence, the very basic of the regulatory philosophy, which is all about the regulatory duopolies, you know, this super famous twin obligations. So let's protect fundamental rights, but also that affects the functioning of the internal market, then, well, I think we can make a strong claim that not having a harmonized approach in terms of data protection at work really touches upon this regulatory duopoly, right, case. So that would be my quick answer to that. I'm not so sure whether you're satisfied.
Yeah, maybe one quick comment on that from the German perspective. I mean, Germany tried, I think, 3 times, 4 times in the past decades, and it also didn't work internally in Germany. So I guess maybe that's indicative of the potential for agreement at European level. Though I understood that in Sweden, they might go ahead in the coming year to draft some specifics on the Article 88. So that's hopeful. But again, that's one country, not the EU level. Then there was a question on access rights, the Digital Omnibus, and that even if the Omnibus fails, which I guess we all hope, that it still will make it more difficult in future to use those access rights effectively, because of course there has been a very clear political signal as to the use of those rights. Somebody want to feel, Thomas, you want to make that?
Yeah, I can try this. I wouldn't be so pessimistic. I think the Court of Justice has been actually very smart in the Brillen-Rottler case, because the Court of Justice has realized and accepted that there can be abusive requests for access, which is obvious. As I said, we experience that every day in the office. But at the same time, if you read it very thoroughly, the burden of proof and the threshold for actually what the controller has to show and what the controller may or may not take into consideration is very high. So the burden of proof is extremely high. And that fits in rightly with how you should apply a law in the first place. You have the GDPR, you have already a paragraph, a provision on that. If there is abuse of rights, you can take certain countermeasures, but it's always on the controller to prove that these countermeasures are justified and that you are using them in a correct way. And the Court of Justice has just added an element to that and say, yeah, you really have to show that this has been abusive and abusive intent. And I think it's the right way to go. The Omnibus, as we have heard, clearly takes the wrong path. So I wouldn't be too pessimistic on the Brillen-Rottler case.
Then there's 2 questions from Eva. The first one was on the question of, do we need a more direct sort of discovery mechanism for workers so they can access their data, but that potentially also for supervisors? Because of course right now it's extremely time consuming. You try to get your data, you get a snapshot, maybe after months, maybe you don't get it, and it's outdated, it's particular, so that takes up a lot of time. So would there be is there a case to be made to create some kind of direct technical access, which exists in other fields of law, like taxation, for instance, for authorities? That's the first question. Let's maybe tackle that first. Okshan?
I think that's a really interesting question. We were talking about yesterday evening. We all together with Eva. From a practical side, I can tell a lot of times when complainants come to us, I tell them I don't know what kind of data the controller has. Of course, you know, under the GDPR, under the Article 85, I can ask the controller or the processor to provide me the data, but in fact I don't have the time. And I was actually thinking about it last night at home in bed, and I know that at least in Hamburg in the public sector, we have some tools where the employees can actually see the data, but they're not. It's not fully developed the way you are thinking about it. I mean, they have an access, but it's not a full access. So, and I think it's an interesting point to look at it much deeper, and I think it would help us as a data protection authority as well as the subject.
Can I come on this as well? Thank you for the question. I think this is one of the things I'd like to recommend to the European Data Protection Supervisor. We would benefit enormously from having a direct access to all the different systems which a controller uses in the EU public administration. So instead of asking for, tell us please what you want, what you have on this and this official, we could check ourselves directly. That would be great. And for the other proposal, the specific, I think the workers' rights, that is a better candidate for specifying, for specification clause. The right of access is already there, but you would very much profit from a specification, what it actually entails in the employment context. The difficulty I see only there is that you have a multitude of systems, obviously. So you need to somehow tailor it to certain systems because, again, it's by a case-by-case basis. And that's where I see the problem, but it doesn't prevent anyone or data protection supervisory authority to provide guidance on specific systems to say, okay, your rights, you have by default access to A, B, C, and that includes the logs on this, it excludes the logs on that, and you can never get this and this information. We do have that approach because we have a limited number of systems in our supervisory universe. But yeah, it's an interesting idea to get the specification, what it actually means for the different types of softwares or applications.
Thanks so much. There was a second question on like a public prosecutor kind of model for workplace data rights. So that, for instance, on Article 80 or any other regulatory model, doesn't matter, but that somebody would be able and mandated to take up workplace data protection with the US model, where you have people who can act in the public interest and take up claims, basically, acting as a private public prosecutor in a way. Does anybody feel called to shed some light on that proposal?
We already have a public prosecutor in a way, that is the Data Protection Authority, actually. And I mean, that's a good idea, but I think that, you know, following also Thomas' suggestion to work with what we have in a way, I think that if we actually enable collective enforcement, then we can save more resources for Data Protection Authority to do their job and act ex officio on more high-profile case that may establish good legal precedents on which other workers may rely later on. Why? Because collective, I mean, data processing in the workplace is by nature collective. And workers' representatives are in a better position than individuals because especially if they have collective rights, they see the big picture on how the data processing is made. For instance, for discrimination issues, if you have the data only of the individual would never understand if there was a discrimination in place. If you have the data of all the workers in relation to that data processing, then you can have the feeling that maybe a discrimination was in place and maybe you can do something about it. So that was my first point. So collective enforcement help to pool the resources that can be free then for the Data Protection Authority acting ex officio. The second point, also coming back on the, you know, the different regimes, Article 80, then general class action regimes, and then other national regimes, sector specific. Honestly, when we did the research at the beginning, that was, you know, our main finding was that it is a real mess and it really depends on national procedural rules, and really the devil is in the detail over there because you have to make strategic choices and then you have multiple choices and then it really depends first on the legislation and second also on the attitudes of the players that play the litigation game in each member state. What I think, also based on the evidence that we collected, is that this type of litigation works better when data protection rights are given directly to collective actors. Because when collective actors, I mean, for instance, in Italy, unions have these special procedures before court that is called anti-union behavior. This can be activated only when union rights are violated, okay? This special procedure is really fast. You get a decision very fast. And then you can get an injunction that would be very precious in this kind of circumstances, because you have to order the employer to change the data processing in that field. And if you do not comply with this decision, then it is a crime, okay? So in Italy, as soon as they give information and access rights to worker representatives, they started enforcing these kind of provisions, and the enforcement was very effective. So I think that, instead of relying on, general class action regimes, special class action regimes, and so on, the real solution is to give rights to collective actors and then allow them to play the enforcement game. Third point, we cannot expect worker representatives to turn on litigation regularly, in a way. Because if you talk with worker representatives, they will tell you, this is not my priority. My job is to bargaining over money, normally. So that's my side job, okay? So how can make this work? We have a lot of NGOs that are specializing in privacy that maybe miss the clients, but they have the expertise and the resources to make this litigation working. If we make worker representatives talking with these type of NGOs, maybe the unions may bring the clients and may bring an interest to the NGO, and with this kind of collaboration, maybe we can make a difference. There were a little bit of experiments of this with the litigation in the Netherlands, in which there were individual claimants, but behind the individual claimants, the Uber litigation, there were trade unions that collaborated with a lawyer that was with specific expertise on data protection, but also there was another initiative coordinated by NOIB with Uni Global Union on access requests against Amazon. I think this is the way, make people with different expertise collaborate.
Thanks so much. We have to wrap up. I already saw a few times some signals on that specifically. Maybe one point you mentioned, civil society organizations working with workers to bring complaints. Of course, we have James Farr in the room who knows a thing or two about that, so I've heard. With that, I would like to wrap up. I found this extremely interesting. I think what I understood from the panelists is that there's quite some consensus that we need more guidance that can come from the EDPB. That would be really helpful, because indeed the rules are a bit outdated, rules, guidelines. Then more transparency would be extremely helpful. And there I'm really positively surprised. I'm really happy to hear that the EDPS has taken this also forward in terms of making their decisional practice records transparent. I think that would do a lot to also help other stakeholders to understand, what kind of decisions are being taken in the workplace and other domains. So that's extremely helpful. And that can be really an example, I think, for other DPAs as well to take up. So it's great to hear. I think collective governance was a key point that was made. So uniform implementation of Article 80 would again also be really helpful. And then, Wojciech, you mentioned the political feasibility of agreeing on rules at EU level. I was a little bit pessimistic, but I'm not that pessimistic to make certain procedural improvements. Because I think that a lot of the stuff we're discussing now, it's actually about harmonization. This is about simplifying things for businesses as well, right? To make decisional records of practice more transparent, gather more data, evidence-based policy making, but also Article 80. Right now, it's just not at all clear how that's being implemented across the EU, and that's the same for a lot of those procedural rules. So some standardization, I think, would be extremely helpful. And I think on really the content of workplace data protection rules, that's of course more sensitive, and there I expect some divergence across member states. But again, there I think there's lots of tools that can help. For instance, certification schemes, voluntary codes of conduct that also haven't really been used up to date in this space. So I think there's lots of room for things to happen also in the coming year, and also in the context of deregulation and Digital Omnibus. Let's give a warm round of applause to our panelists. I really appreciate you made it.